The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you and good afternoon. Welcome to this special Zoom session of the Appeals Court. We're hearing just one case today, which is docket number 24P149, Penzie versus Boylston Brookline LLC and others. Your panel for today is me. I'm Justice Massing. We also have Justice Englander and Justice D'Angelo. We try to run these Zoom proceedings the same way we do in a courtroom. So, which is the appellant gets 15 minutes, the appellee gets 15 minutes. There's no rebuttal. And we've read your briefs and materials, so we're prepared. So you can just jump right into it. You're free to use your entire 15 minutes. There's no penalty for finishing early. The only thing, I guess, when you're not speaking, we ask that you mute yourself, stay on the screen so we can see that you're still here, but also try to keep reactions or gestures to a minimum because that can be very distracting to the panel. So how would I say your name? Is it Ms. Penzie?
It's a Pense.
Pense,
Yes.
Okay. It's your appeal, and you have your 15 minutes will show on the screen where the clerk was.
Thank you so much. May it please the court, thank you so much for allowing me to speak. My name is Shona Pense. I'm a physician and mother of three who is appearing pro se. I will address why the land court's fee award under Section 6F cannot stand. Your Honor should each have a bench sheet which provides the page numbers in the record appendix to which I will refer in my oral argument. So my theme in a single sentence is that Section 6F opens the fee shifting door only when, and I quote, all or substantially all of a party's claims are wholly frivolous. Yet the land court itself found that 16 of my 17 claims were properly, quote, properly founded in the facts and law. The land court only found one of my 17 claims to be frivolous, and that one claim was my individual standing. One does not equal 17. When just one claim fails, the statute's door does not open. Record Appendix 160. By way of a roadmap, I will make 3 points. The first is that the quantitative threshold of Section 6F is unmet. Section 6F requires all or substantially all claims to be wholly frivolous, and the record, in contrast, shows just one out of the 17 were deemed to be so. Since one does not equal 17, the award cannot stand. The SJC's ruling in Danger Records versus Berger requires reversal on that basis alone. My second point is that there was no bad faith, since even the single claim that the court rejected, that of my individual standing, was supported by good faith precedent, since I owned the deeded LLC and lived in the home with my 3 children for over a year before the ZBA application. Indeed, taking into consideration this court's ruling in Quimby versus ZBA Andover, where standing was granted based upon real interest in the property and not just the name on the deed, this should support and indeed require reversal in this case. Even if the 6F threshold is ignored and the good of living in the home.
Sorry, what was the case you just cited? The Andover case?
So it's Quimby versus ZBA Andover.
You cited in your brief, correct?
Yes.
Okay.
So Even if the Section 6F threshold is ignored, and the good faith of living in the home with my children is ignored, and my being the managing member of the record owner LLC is ignored, even if all of those are ignored, the fee calculation in and of itself was erroneous. A flat 30% of a $318,000 amount of legal fees violates Section 6F's requirement that fees must correspond to defending the allegedly frivolous claim. Here, it was
Okay,
only one claim. Oh,
Ms. Pensy, I'm going to interrupt. And this is the way we do things. So we interrupt. It's harder to do it when we're on Zoom. But so here's the first issue that I have. You say that 16 of your 17 arguments were not frivolous, but in doing that, you've collapsed the arguments made by the trust with the arguments that you made in your individual capacity, right? In other words, the arguments that the court found not to be frivolous were arguments that were made by whatever the name of the entity is. Now, did you in some way join those arguments as an individual? Because you had two different lawyers, right? The trust had one set of lawyers and you had another, right?
well, the complaint was common and it was the same lawyer.
Okay. Why? I thought I read this morning that you had a lawyer that was different than the
Yeah,
lawyer representing the
it was the
trust.
same lawyer through almost everything except the hearing.
I see. And what is in the record? And the concept of record may be hard for you to deal with, but what I'm trying to find out is what did the lower court know about your relationship to the trust?
The trust was essentially me. I was the managing member. I was it was just done because when during 9/11 I had seen so much discrimination, but at the time I thought it was best to put it into to a trust so that my name sort of wasn't on the deed itself. But I gave more than 85% of the money. I was the
Okay,
managing
so I saw
member.
that in your
But
brief.
it was
Was
just,
that in the
yeah,
record? Because the judge did not reference that. In fact, I think the judge
yeah,
says that she does not know. She was not
it,
told what the ownership of the trust was.
it was in the record.
Okay. And where, in what form was it in the record? How much money, what
Um,
percentage of the trust you had contributed?
I can get you the page numbers.
Okay.
Uh,
You don't need to worry about it. If it's there, we'll find it.
But although
Okay.
maybe was it in a paper that was submitted? Was it testimony? That'll help us.
it was in, I believe it was both in testimony and in papers, I think, but I can confirm and find it and get back and send the page numbers, but I think it was in both.
Okay. Now there's another question, unless uh, Judge Massing or Judge D'Angelo have follow up on that. I have another, I'm going to switch gears. Just
Let
go
me just
ahead.
one more. Yeah, if it was in paper, was there documentation that laid out the percentage and the percentage ownership of the
Yes,
LLC? Okay,
yes.
thank. Go ahead, Justice Englander.
So the other thing that you say there was no bad faith. The judge found that I believe it's your ex-husband acted in
No,
bad faith.
and
Well,
not ex-husband.
the children's father, is that right?
Yeah.
Okay. So the judge found the children's father uh, basically lied to the court. I'm for lack of a better description, let's leave it at that for now. And if I'm wrong, you can explain why later. But she was very concerned about the fact that he took the position he had a lease, and then at the same time had filed something in the federal court that seemed to say opposite of what he said in his pleadings in Massachusetts, and seems to say and find that you helped him, the judge makes findings to the effect that there are a series of documents signed by you. What do you say to that?
So it was not his primary residence. He stayed at the home with my permission, but it wasn't his primary residence.
Okay. What do you say
At the
to the judge's concern? It really comes in two pieces to get at you. She's concerned that he didn't tell her the truth and that you helped him by signing documents to that helped him make those arguments.
Yeah, no, she never explored the sort of the those matters. The She never explored, she just stated them afterwards. So it after the fact, sort of assuming that something had happened, but there was nothing that had transpired. I mean, the only reason we changed or that I try the only the only reason that the deed changes were made was to get money. And I was going to get to this, was to get money during the COVID pandemic for a humanitarian sort of project to get cash out for the humanitarian project for COVID-19 ventilators and living expenses, to get some cash out equity.
Was that explained to the judge?
She did not, she never explored those matters, so I didn't have a chance to explain that.
So she says, Pensy, I'm reading from page 8 of her findings. Okay. Pensy engaged in numerous title transfers after the board's decision was issued and this lawsuit was filed in an attempt to manufacture individual standing both for herself and for Murcia. And then these undertakings began June 25th, 2019, signed a deed transferring ownership from Boylston D3 to both Boylston D3 and herself. Initiated this transfer on the same day that the verified amended complaint was filed out of her concern that you needed to have individual ownership or interest. So that part I get.
Yeah.
But then she goes further and says transferring 615-17 Boylston Street from Pensy to Boylston D3 to themselves and Murcia in aid of Murcia's effort to claim individual standing on the eve of trial. And she says, you signed these documents. What do you say to that?
Well, that was done, Murcia was added to because he had given some of the money for the property.
Yes.
And because to get cash out for the cash out financing, I had to buy the property at the time of the COVID pandemic just to meet expenses. So I had to buy the property from someone other than myself to get cash out financing, which was what one of the people that I asked about, some help with getting the refinancing had recommended. And that's
And
why
your position is that what you're telling us now was not inquired into by the court at
exactly.
trial and therefore is not
Exactly.
in the record. Okay.
Exactly. It was just to get cash out financing so that I could buy it and then get money out for for the COVID related venture,
Okay.
for ventilators.
You've answered my question.
I
Thanks.
wanted to ask, the the judge had no problem finding that the Boylston D3 LLC had standing, had presumptive standing. I mean, I guess later they're not, that they didn't carry their burden once it was shifted. But why did you feel it was necessary to create individual ownership when you could have pursued the same claims through the LLC?
So the attorney had told me that it was needed at the time. I had hired him through Craigslist, and at the time he had said that I needed to have individual individual into the claim as well as the the LLC.
Okay. So if you have
Should
if
I
you've got it, yeah, go ahead. Go ahead.
Oh, I have, should I continue with what I
Yes,
prepared?
you still have
Okay.
almost 2 minutes.
Okay. So even if the 6F threshold is ignored, even if all of these items are ignored, the fee calculation in and of itself was erroneous because a flat 30% of the $318,000 amount of legal fees violates 6F's requirement that the fees have to correspond to those fees needed to defend the allegedly frivolous claim. So here we had one claim of the 19 claims advanced, 16 were common zoning claims, 3 individual standing claims, and thus only about 5% of the claims were found to be frivolous. Thus, I respectfully request reversal or at a minimum, a request for remand for a proper line item analysis. I wanted to cover all of these in detail, but I don't know that I'll have time. Um, but uh, um, Section 6F demands that all or substantially all of the claims be frivolous. But the other 16 claims in the common complaint were all found to be properly founded in the facts and law. In Danger Records versus Berger, the SJC vacated a fee award because the judge did not find all or substantially all of the claims to be frivolous. The appellees acknowledge this mismatch. However, they reframe the statute to be quote, all or substantially all of Pensey's claims as to standing. But that's not what the statute says. The legislature didn't insert that qualifier as to standing, and the court shouldn't do so. It should be, just as the statute says, based on all of my claims and not just my claim of standing. So with 16 concededly valid claims, Section 6F gate is locked. And then I will stop there, I guess, because I've
Okay.
run out of
Yes,
time.
thank you. No, I mean, we do have your brief and the other materials you filed, so we'll look at that all carefully.
All right.
So if you would please, mute yourself and stay on the screen, and again, and try and see try not to make faces, and we'll hear from his attorney. Is it pronounced Gentile?
Yes, Gentile. May it please the court, Don Gentile on behalf of Boylston Brookline LLC. The first note that I would like to make during this argument is the standard of review. As you know, chapter 231, section 6F is appealed to the single justice, and the single justice has already reviewed these orders. And he reviews the order as if he were the judge originally making the determination.
Let's use the pronoun she for Chief Justice Blake, okay?
And the single justice stated that I discern no error of law or abuse of discretion. Your standard of review
Do you concede, counsel, that we still have review for errors of law?
Absolutely, Your Honor.
Okay.
There was no error of law or abuse of discretion here in this case. You have two extremely thorough decisions by Judge Rubin of the land court.
Right. So I'm going to lay my cards on the table. I don't know where these guys are, but $100,000 personal, where the only issue that the court was concerned about, that the court thought was frivolous, was standing, strikes me as extraordinary, counsel. What do you say to that?
It's absolutely not, Your Honor. The standing is the absolute gateway issue in a zoning.
Yes, it is. We're very familiar with that.
And we spent the lion's share of this case litigating that issue, Your Honor, because what we
including whether or not the Minnesota corporation that represented the trust was properly identified as somebody who could bring a suit in Massachusetts, right? Even though that turned out to be something they could fix, right?
Your Honor, we filed a motion to dismiss on that.
So whose choice was it to litigate that issue, counsel?
Your Honor, we decided to file that motion under
Right.
the statute. And as we proceeded in this case was.
I mean, how is she not in a butter? She's living there and she has 3 children. She cited a case to us which suggests that she didn't need to be an individual under those circumstances. She didn't even need to show she owned. Is she right about that, the Quimby case?
No, Your Honor. First of all, I would say that this court does not go back and relitigate these issues. Second of all, Your Honor, you asked earlier what's in the record, and the answer is nothing. We've dealt for years with these claims. Today it's one point, they bring up something else, they file a different deed, they say something
I
else.
thought we were talking about standing, and I don't think you're answering my question. My question is, she lived there with her 3 children. As an abutter, she can make the argument, if she's an abutter, that she presumptively has standing, correct?
If
If
that was
she's
in
an
the record,
abutter,
if that was in
if
the
she's an
record,
abutter. Well, oh, you mean it wasn't in the record that she lived there with her 3 children?
Your Honor, we don't know where she lives, when she lives. It's not in the record. Sometimes, right now, the property has been conveyed.
When she testified, they didn't put in the record that she lived in the house with her 3 children. Is that what you're saying?
My memory from the record is that she lived at the house during different periods of time. The testimony on those issues was spotty. It wasn't
I
definite.
thought the judge actually found that she lived there with her 3 children. Let's assume that the record shows that she lived there with her 3 children, counsel. Okay? Is she right that the Quimby case indicates that she has standing independently of even showing an ownership interest?
I don't think so, Your Honor. I don't.
Okay, well, I'll take a look at that.
I think the question's nuanced. I think she needs more than just claiming that she lived there for some period of time. I'm not sure she needs an ownership interest, but I think she needs more than what they showed at trial. And the issue, Your Honor, is that
If they showed a trial, I'm sorry to be difficult with you, but I think the problem with $100,000 assessment that she's taking personally in this case would be if she in fact lived there next door and proved it. Because then I would think she at least has the ability to argue that she presumptively has standing. And the kinds of arguments you're making now, you're the one who's ratcheting up the costs, because if she lived there and she proved it, then why are we litigating the issue of whether she presumptively has standing, as opposed to the arguments you made and prevailed on, which are that she hasn't shown that she's personally aggrieved and that you've overcome the burden. You follow me?
Your Honor, she did not prevail on that claim after 2 years of litigation and a 4-day trial before Judge Rubin. She did not succeed in proving that she had a butter standing. She lost.
She may not have prevailed, counsel, but what in her testimony or an argument made it frivolous?
The argument that she was perpetrating, Your Honor, is one fraud after another being perpetrated on the court. She would file deed after deed. They would create chaos in this litigation at every step. They made baseless arguments when they were convenient, and then changed their arguments. Litigating this case was like a game of whack-a-mole in the absence of evidence. I would suggest to you that your docket in this appeal is an example of what happened in the underlying action. It's just one stunt after another. As Judge Rubin found, it was gamesmanship. It was outright gamesmanship on her part. And
I just want to, is it on her part or on counsel's part? And does that make a difference?
she was acting through counsel, Your Honor. She was represented by counsel during the entire case. And Your Honor, when none of this is, the record, to the extent she was taking advice of counsel, or she's going to claim that her counsel forced her to do something that she was not intent on doing so, or the conversations between counsel, this is what we see in this litigation, Your Honor. It's not in the record. It's not in the record. It's all last minute filings, pure argument without evidence. And respectfully, Your Honor, she or her lawyer will say whatever is convenient at the moment to get past whatever argument is in front of their nose. So we
Okay, so that's a lot. That,
filings.
I find that extremely conclusory. I'm sorry, I'm going to be difficult, okay? Because I'm looking at something that doesn't make sense to me. The sort of, oh, she's bad and she did this and she did that. I mean, let's start here. I think there's a finding that she lived there with her 3 children. Am I wrong about that? Did
I-
she not prove it?
Your Honor, I don't recollect that as I stand before you. I did not think that issue was under review today because it was a factual finding in the underlying.
Not, this was frivolous, doesn't it? I mean, whether or not her claim to standing was frivolous starts with whether or not she's in a butter. And if she lived there with her 3 children, she makes the argument to us. I don't know how you don't know this is in front of us. She makes the argument. There's a case that says that's enough by itself. Okay, which by the way, I'll tell you makes sense to me. I'll go read the cases, but that makes sense to me. Now, if she has presumptive standing, then we go, you have the opportunity then to rebut that, right? Which
Yeah.
the court found that you satisfied, right? But was it, as Judge D'Angelo says, frivolous for her to argue her standing? One of the issues they argued in standing was density, correct?
They use the word density.
Okay. They testified as individuals, and I understand that point very much. Okay. But there were 4 substantive arguments made about the violations of the Brookline bylaws with respect to your proposed development, your client's proposed development. And with respect to those 4 arguments, every one of them, it seems to me, at least falls within the penumbra of the word density. 2 of them had to do with the fact that they said that there was not sufficient setback. One of them had to do with floor area ratio, and the last one was that you have too many units. Now, I don't understand. Am I right about that?
You're right that they said that and that there was 0 evidence. And this is a zoning appeal, Your Honor, in which case our client received certain zoning relief under the Brookline bylaw. There was no mistake, Your Honor. It was discretionary relief. And it was their burden to make the argument that they prevailed on the merits. They offered 0 evidence for this, Your Honor. For example, you say that they argued that they didn't have sufficient setback. There was no evidence offered on that point.
A component of each one of these arguments appears to me, as you said off the top, we don't get to go back and relitigate this given the standard of review. Understood. On the other hand, in order to try to figure out whether an error of law has been made with respect to the assessment of a 6F fee, we have to look at it to some extent.
Sure.
I looked at the 4 arguments. I looked at how the judge dealt with those 4 arguments. They appear to me to have significant legal components with respect to construction of the bylaws, questions of law with respect to construction of the bylaws, didn't they?
Your Honor, they did not bring up valid claims. We
The
fulfilled
judge,
we
I'm sorry,
fulfilled
what do you
our
mean they didn't
obligation.
bring up valid claims? The judge found they were non-frivolous.
Your Honor, what happened was they claimed that certain mistakes were made, and we fulfilled our burden of coming forward and bringing evidence before the court in order to essentially explain away any conceivable claim that they could muster. There was no issue. And what we did was we essentially proved the negative in order to get through the zoning appeal. There was no evidence offered.
It seems, counsel, may I? It seems to me that that's an argument that those 4 arguments with respect to the zoning bylaws were frivolous. But the judge did not say that. What do you say to that?
Your Honor, the judge focused on the standing issue, but the case in its entirety was devoid of any evidentiary or factual basis.
Well, except the judge did find that Boylston D3 was entitled to standing by right, correct?
Your Honor, the court found that Boylston D3 LLC wasn't a butter at the time that the case was filed and thus entitled to presumptive standing. All that means is that Boylston D3 LLC held title when the complaint was filed.
So
That's all that
in-
means. It doesn't, Your Honor, it doesn't mean that that Boylston D3 LLC offered valid claims.
I understand that, but in some way, and I don't think we need to get into the minutia, Ms. Pensy was affiliated in some way with Boylston D3, correct?
Maybe, Your Honor. What I'm trying to say is that admissible evidence was lacking on these issues. Neither Ms. Pensy nor Mr. Merkia nor the attorney offered evidence to substantiate these claims. And instead, what they do is they bring up these issues in the form of conjecture when it's convenient, as they've done in this appeal, Your Honor.
Well, again, I mean, I know you're saying that she was maneuvering things. To me, to a certain degree, there's also a shell game going on regarding standing here. If D3 has standing as of right, which the judge found, and I think that's actually in the fees decision, I think that the judge said, as noted in the trial decision, only Boylston D3 was entitled to a presumption of standing as the fee owner of the abutting property. So if Ms. Pensy in some way is part of Boylston D3, she has standing in some respect.
Your Honor,
Right.
first of all, I hate to get into the weeds, but the judge found that Boylston D3 LLC was entitled to a presumption of standing. That's not standing as of right, number one. So Boylston D3 just gets a presumption, okay?
It does shift the burden to you to come up with the evidence of that they lack standing. To create a
Yes,
something
Your
out. So you do have to prove a negative.
Yes, into the,
So if that is the judge found, it shifts the burden. I agree with Justice Massing. How are her claims regarding standing frivolous when the judge is saying, again, I'm going to use Ms. Pensy incorporating as D3, that they have presumptive standing? That's where I'm struggling. What makes it frivolous at that point?
because Your Honor, you talk about a shell game. They were playing a shell game with respect to Boylston D3 LLC. So the evidence was not in the record that she had a certain ownership interest or she was acting in a certain manner. It was lacking, and it was their burden to bring it forward, and they did not. And to the extent that Boylston D3 had presumptive standing, again, all that means is that they held title when the lawsuit was filed. That's what it means in the context of this case. It allows you to draw no additional conclusion as to Ms. Pensy. And the other thing I'd add is Ms. Pensy was in the process of aiding Mr. Merkia's, again, and I don't mean disrespect before the court, but it was a fraudulent scheme in gamesmanship in order to prove that he had some stake in this property. And that's what was going on here. It was a scheme.
Let's assume that that's the truth. Merkia was engaged in some sort of shell game in order to establish his individual standing. Pensy helped him with respect to that. $100,000, 30% of the fees in this case?
Your Honor, respectfully, if you look at the docket in the underlying case, and you look at the 78-page findings of fact from Judge Rubin, you will find that that is absolutely appropriate because of, respectfully, Your Honor, the chaos caused by Ms. Pensy and her attorney with respect to the shifting of the property, with respect to the motion practice, with respect to every single aspect. I don't say this lightly, Your Honor, every single aspect of the underlying case in land court. It's absolutely appropriate, Your Honor. And I think if you look at the record, you will be just as convinced as I am. If you look at even your appellate court docket for this matter, it gives you a small sampling of what went on in the underlying case. It's inexcusable, Your Honor, respectfully, and I'm not being hyperbolic. I'm not. There's other things going on here, Your Honor. you know, there's a lot going on with Mr. Murchia and Ms. Pence outside of this specific appeal. And I'm not overstating the fact that if this is not a case for 231-6F, Your Honor, then respectfully, the statute has no power. Because this is this is the worst scenario that I can envision in a land court zoning situation. It was unrelenting, it was continuous, it was a scheme, it was everything Judge Rubin found.
It was a scheme? How was it a scheme? She lived there. The people next door wanted to build 13 units. And 4 of the arguments made were, you're too close, that's too many units, and your floor area ratio is too high. And I read what Judge Rubin wrote, and she had to wrestle with what appear to be, and I looked at them, not the clearest bylaws of the town of Brookline on those issues. And she came out your way. She came out your way. You won that. But that doesn't make something frivolous.
Your Honor, I wouldn't say that she had to wrestle. I think what she did was she explained the evidence as we presented it with witnesses. And there was
Well,
no
the first question is a
evidence.
question of law. The first question has nothing to do with evidence. It's a question of law. Now, if they're ambiguous, then yeah, and so you put somebody on to explain them to her, but that doesn't mean it's a frivolous argument off the top, counsel.
But there was zero evidence offered in support of the claims, Your Honor. There was no.
They don't have to, counsel. If it's a question of law, all they have to do is make the argument out of the bylaws.
Your Honor, they need to substantiate their zoning appeal under the zoning bylaw with admissible evidence. They absolutely do. It is not.
Sorry, we can disagree on that. I think your time is up anyway. I don't know. Maybe my colleagues have questions.
I don't. Just D'Angelo? Okay, no, the time is up. And if Justice Engler, you no more questions?
No, I'm done.
So the case is submitted. I want to thank you both for making the time to we originally put this down to not argue, and we appreciate you both making yourself available for the argument. And with that, we'll adjourn. Thank you.
Thank you both.